Good morning. This is John Milburn, providing some commentary in relation to Introduction to Law, Laws 11057. This is week 9, and we commence the process of dealing with legal research. That's not entirely correct, because throughout the course we have talked about different ways of researching. And you'll recall that there are a number of different options available to you in terms of online and other resources. So what I plan to do today is to apply the legal research that we've learned during the course so far in a meaningful way. Before doing that, I just want to remind you that the university does have online resources in relation to student policies. So if you look at the IM portal, you can see student policies in relation to a range of issues. And I'm just going to pull that up on the second screen that I have here so that you can have an idea of exactly what it is that I'm looking for you to consider. So bear with me while I share the screen. You should now see my second screen, and you'll see the portal that I referred to, which provides the university's policies and procedures, plans, committee terms of reference, codes, charters, guidelines, and templates. So the policies and procedures are relevant to you in a number of ways. For example, the assessment of coursework procedures, grades and results procedures, but particularly I'd like you to consider plagiarism procedures, student misconduct and plagiarism policy, and the students' complaints policy. There's also some notes in relation to the use of internet, email, and computer facility policies as well. So I'm not suggesting that you need to undertake anything more than be aware that those policies are there and to consider those policies in the context of the work that you provide. Okay, so in terms of week 9, legal research, we often have referred you to a text called I'll come back to that, a practical guide to legal research, but that text is no longer prescribed, and but I do refer to it from time to time, and you'll see a reference to that in the notes. It may well be prescribed again in the future, but it's not this term, and it may be a text that's worth considering acquiring if you wish. All right, so in terms of legal research and legal reasoning skills, you'll recall that we mentioned a few acronyms. One is IRAC, IRAC, and that's the process for lawyers to identify the relevant facts, or the legal issues rather, to determine the rules, apply those rules, and state the conclusion. So that's I, identify the legal issues, R, determine the rules, A, apply the rules, and C is state the conclusion. Now, even though that's a way of reading cases, perhaps even legislation, and writing about those things, it's also a valuable thing to consider when legal researching. And when you're doing your legal research, you need to be mindful of a few things. One is identifying the material facts. So you need to identify what are the terms, the words, the phrases that are relevant to your legal research. Now that may be difficult, I understand, unless you know the law, but bear in mind that research is not necessarily a linear process. What I mean by that is that it's not necessarily going to be a case of starting at point A and going directly to point B. You may need to consider different alternatives. Look, one way that I find is useful when legal researching is to create a chronology or a list, and you try to identify what you've got, try to identify what's missing. And so you're asking yourself a lot of who, what, where, how type questions. And if you ask yourself those questions in the course of your legal research, you may be able to identify different ways of arriving at a different or the appropriate response, or result rather. Okay, through the authorised and the unauthorised online websites, during the course of this session course, we have talked about the ways that you can identify and interpret rules to do with legislation and case law. Also, in terms of legal research, you'll recall that we talked about legal reasoning. And legal reasoning is important for research as well, because you may need to use your skills of reasoning by analogy, which is dealing with similarity, when considering precedents. You might need to consider your legal reasoning skills about inductive reasoning, which is broadening the approach, where you look at a specific principle to form a general conclusion. And you may need to consider deductive reasoning, which is where you narrow, where you take a general principle back to a specific conclusion. So these are sorts of things that you might also consider in the general context of legal research. All right. When it comes to online resources, Ostly is unauthorized, but it's still very good. You should by now know the Note Up function and the Law Site function. If not, have a look at previous tutorials, and otherwise just go on the website and make sure that you're aware of how to use those things. Also, you should be aware by now of how to use Boolean connectors. So use the double quotation marks around a term, or so it reads as a phrase, and that's a good way of effectively providing some research. So when it comes to your legal research, work quickly but thoroughly, and think laterally are the key things for you to consider there. All right. In terms of authorised sites, we've looked at ComLaw. We've also looked at the Office of the Queensland Parliamentary Office of Queensland Parliamentary Council. There's a new website for them now as well, and there's some excellent online resources from Dr. Marinak. Also, there's some resources from me and our former librarian, Kelly Stitterford. Okay, let's now think about another aspect of legal research, and that is using the resources that are online, that are readily available to you, and which are, if you like, authorised. So I'm going to take you now to the Queensland Courts website. I'll call that up on the other screen. If you can bear with me while I share that screen. Okay, so you should see my second screen now, and you should be very familiar with this website by now. You'll see that there's a section here at the top on the ribbon for lawyers. Go to that, and you'll see a couple of things that I want to bring your attention to specifically. One is bench books. Look, bench books are a really valuable resource. They're written to assist not only members of the public and lawyers, but also to assist courts. Now, the ones that I want to bring your attention to are the Domestic and Family Violence Protection Act Bench Book. This is a very valuable resource if you have anything to do with domestic violence, and it provides you with a great deal of legal and other information. And bear in mind that the courts, magistrates in particular, will be looking at this resource in determining the law and how to apply the law in a way that is consistent. And as a result of that, if you want to be arguing persuasively, it's advantageous to have access to, read and consider the same material that the courts have access to, read and consider as well. So that's prepared through the Magistrates Court of Queensland. I absolutely commend that work to you. Also, we have the Equal Treatment Bench Book. Now, this is a Commonwealth piece of work, and Supreme Court of Queensland piece of work, and it provides a great deal of information in relation to broader issues to do with family, cultural issues, and issues to do with children, domestic violence, gender equality, etc. So I'd commend that to you, the Equal Treatment Bench Book. Now, finally, in terms of bench books, bear in mind that in the Supreme and District Court bench books, there are a whole range of bench books that are written as if being delivered by a judge. So have a look at this one, Trial Procedure, for example, and it gives you an outline of the trial procedure in District or Supreme Court jury trials. It's scripted, so that you can see exactly the words that are said, or a pro forma of the words that might be said. The judges read these and apply these bench books. That's why they're called bench books. But they don't have to. They can use their own wording if they prefer. But it is a guide or a script, if you like, for the judges in undertaking their work. So bench books are an extremely valuable resource. Now, while I'm on that same page of for lawyers, I want to show you this one here, practice directions. And practice directions apply for each of the courts, and you must become familiar with those practice directions. Also, QCAT has its own practice directions as well. Okay, I'll stop the share now. So when it comes to legal research, you need to consider your technique. You need to consider where you will look and have that organised, ready to go in terms of authorised and unauthorised sources. And you need to be able to supplement that by reference to materials that are very valuable, particularly those materials that are used by the courts themselves. However, in practice, you never have a situation where a client comes to you and says, I want to engage you to provide me with a critique of a certain case, or to outline what this section of the Act means. So the sort of typical exercise that you see provided to law students in law schools about that is very artificial. It's not going to happen in practice. What happens in practice is that clients present you with a problem, and your job is to identify the material facts, identify the legal issues, apply find the rules and apply those rules, but all in the context of providing advice and assistance to the to the client, with a paramount duty to the court. Now, when you're providing that assistance to the client, you must also consider that it's not just a matter of strictly applying the law as you see it in a litigation sense. Your advice needs to be holistic. What do I mean by that? Well, what I mean is that you need to consider a whole range of different options that may be available for the client, and that may require some straightforward, typical legal research, or it may require lateral thinking and broader research using and applying different agencies to assist you. So in a first interview situation with a client, sometimes I think of it as a legal triage, where you're identifying the nature of a problem and then identifying a whole range of different options that might be available, and tailoring the advice that you give and the assistance that you provide to the client, bearing in mind the needs and the personal circumstances of the client. Now, let's talk about some of those things. The client. I guess clients sometimes come to you logically, but very often they come to you emotionally, and you need to weigh that up and make that assessment. It's very easy for people to make snap decisions that are not ultimately in their best interest. So without being paternalistic about it, your role is to at least guide them and provide them with advice. But you need to take into account their circumstances. So some of those individual circumstances might relate to the individual's intellect, socioeconomic background, age, cultural factors, risk perspective, and issues to do with funding litigation. You might also ask yourself whether there are capacity issues. So a person who is borderline disabled may want to, may need guidance, or may even need an administrator or guardian. So you need to separate an ideal legal outcome, which is very neat and clear litigation, against what it is that the client necessarily wants or should do. So as an advisor, you need to consider both the legal and the non-legal options that might be available to the client. So how do you make sure that you're advice is tailored to the individual needs and circumstances of the client? Well, you need to find out about the nature of the problem, about your client, and also the other side. So there's a lot of listening in that first attendance, particularly at the start. You need to consider a whole range of things. Maybe self-help is an option. Maybe there are specialist services that are non-legal that are available to the client. Perhaps some sort of early intervention strategies need to be considered as well. You may have ethical issues as well. So a client may be hell-bent on litigation. You know that it's not meritorious limitation. You need to consider whether or not it's ethically appropriate for you to consider with that litigation in those circumstances. In terms of options that are available to a client, let's think about some of those. One is that it may be that the client is best to simply walk away from the dispute. It's not often talked about, but even if there's an amount of money that's substantial, or even if there are issues of concern that are considerable importance to a client, it may not necessarily be best for that client to pursue that remedy. Another option is to make a direct approach. Maybe discussing something with a neighbour over a cup of tea is the best way to resolve it. A more structured way of resolving issues might be through mediation. And there are free services or near free services through the Alternative Dispute Resolution Centre, or there are paid services through lawyers primarily. All right, so what other options are available to a client if we're thinking of the whole range of different things that the client might consider in terms of dealing with a legal problem? Well, maybe you can call upon your Member of Parliament to help. Or, depending on the nature of the problem, go to an ombudsman. The ombudsman might be the government ombudsman, which deals with public agencies to make sure that they make fair and right decisions. It might be the telecommunications industry ombudsman or the banking industry ombudsman. And there's the different financial, there's the financial services ombudsman, the credit ombudsman service, the insurance ombudsman service, the energy protection, energy and water ombudsman. So a whole range of different agencies that may be able to assist in making sure that individuals are protected. Now, that may not necessarily mean that the lawyer has a great involvement, and it may not be as financially lucrative as litigation, but it may be a better result for the client, and you need to bear that in mind. All right, depending on the nature of the dispute, there are other things that you might consider at that first instance as well. For example, it may be a police matter. Or it may be that commissions can help you, or statutory bodies. So the Office of the Public Guardian may be able to assist in terms of investigations. The Anti-Discrimination Commission or the Superannuation Complaints Tribunal, maybe the Welfare Rights Centre if it's a Centrelink issue. Maybe the Seniors Legal Service if it's a senior and there are issues to do with exploitation. If it's a debt matter against a company, then instead of suing in the usual manner, perhaps you could consider a statutory demand, which is a formal notice requiring payment within 21 days. If the company fails to respond to that notice, it's deemed to be insolvent. So it's a very powerful tool. But you need to tread carefully if you do that one. Finally, you might consider the media as an option. So the whole range of different things that you can consider, I like to think of it as brainstorming, when you're considering a client who is in difficult circumstances. Right, next week, I'm going to take this a little further and ask you to consider a situation where a client asks you to institute proceedings. I'd like you to consider the appropriate court or tribunal that you believe is appropriate, and the circumstances that we'll deal with are: your client wishes to pursue a debt of $5,000, your client wishes to pursue a debt of $50,000, your client wants to sue as a result of a faulty refrigerator worth $2,000. Your client wants to sue as a result of a faulty motor vehicle worth $30,000, and your client wants to sue for an anti-discrimination matter. So within the context of now applying your legal research to situations that are more realistic, that's what we'll continue to talk about next week. So this week, please undertake your research, or advance your research skills. One of the best ways of doing that is just to get in and start to work these websites and find these other pieces of information such as bench books and practice directions that might assist you. And start to think about how you'll apply the law that you are learning in a more realistic situation. All right, I'll stop the recording now. All the best, and we'll see you next week. Bye.